Glad to see the fog didn't affect anyone this morning getting in here. I assume that the operation of the clock is familiar to you both, and if the appellant will, Mr. Ireland, you'll tell me how much time you want to reserve for rebuttal. We'll
reserve about 5 minutes.
Great. You may proceed. Thank you.
Please, the court. My name is Leonard Ireland. I have the pleasure of representing Shakespeare Foundation and Herd Community Development Corporation. Ms. Downing represents the appellees in this case, Mr. and Mrs. Jackson and Jackson Realty. This is an appeal from a final order granting a motion to dismiss the complaint that we filed in Bay County based on an arbitration clause in a contract for the sale and purchase of certain lands in Panama City, Florida. Our clients purchased a parcel of land in Panama City to develop affordable housing. They purchased this land based on a multiple listing in the multiple listed service in Bay County, which advertised the land to be a great affordable housing project. But more particularly, there was a clause in there that said, wetland study verifies no wetlands. Multiple listing was prepared by Ms. Jackson, who's one of the defendants and one of the appellees in this case, who is a realtor. And at the time that she prepared that multiple listing, she knew that 26% of this land was wetlands because she had had a study done before she purchased the land from about 6 months before that she sold it to our clients.
Mr. Allen, let's go directly to the arbitration clause.
All right.
As I've looked at all of these cases, it looks to me like it's a question of how we read Seifert and how we read a line of DCA cases coming out mostly the 4th and the 5th. While I agree with you that the extent of an arbitration provision is a matter of contract interpretation, the intent of the parties, your brief really didn't address the Beezer case, the McGuire case, and some of these other 5th DCA cases, which have held that fraud in the inducement, where it's directed at the entire contract, it is resolved by arbitration. How do you distinguish or read those cases so that they at least don't provide us some persuasive authority?
I don't believe that those cases have anything to do with the situation that we have in this case because of the particular wording of the arbitration clause in this case. And the arbitration clause in this case says, in the particular portion of it, says the arbitrator may not alter the contract terms or award any remedy not provided in the contract. There is no remedy provided in this contract for the situation that's before the court. There's absolutely none. So I don't believe that there could ever be any reasonable person could believe that there was the intent of these parties to enter into a contract that for fraud would not give them any remedy.
But the McGuire case has language, sort of the introductory language in the arbitration provision. All controversies here, all controversies, claims, and other matters in question arising out of or relating to this transaction or this contract or its breach will be settled by arbitration. That's almost the exact language that was in McGuire.
With the exception of that last language, there are two provisions in this particular contract that I demand that this go back to litigation. The one is the arbitrator may not, this is in paragraph 14B, the arbitrator may not alter the contract terms or award any remedy not provided in this contract. What's the arbitrator going to do? That's not, and I don't believe that's in McGuire. I've not seen that in any other of the cases. The second part of the provision is in the latter part of paragraph 14B, which says any dispute with a real estate licensee named in paragraph 17 will be submitted to arbitration only if the licensee broker consents in writing to become a party to the proceedings. Mrs. Jackson was named in paragraph 17. Jackson Realty was named in paragraph 17. There is no provision in this particular contract for the arbitration of this issue. There's nothing, I don't know what the arbitrator could do because there's no remedy in this contract for fraud. There's remedy for not closing on behalf of the seller and the buyer. There's remedy for return of the binder deposit. But outside of that, there is nothing.
Is there any relevance to the provision in the contract that speaks to the buyer's ability to perform a feasibility study on the property, which would have included an environmental assessment? And if the results of that feasibility study were not acceptable to the buyer, basically the contract would be over?
If we get to that issue in the trial, there may very well be, but that's not a matter of motion to dismiss. That's not a matter of sending it to arbitration.
I understand that, but what would be, if you'll indulge us, what would be the defense to that argument at trial? Just, again, I understand you're not conceding that that is relevant to the issue on appeal, but if at trial and I guess the reason I'm asking is to see if there's any interplay with arbitration. The defense is you had 30 days to conduct your own wetlands evaluation, and you failed. So you have no cause of action for fraud anyway.
I'm not too sure that the overt fraud in that, if this was something where they made no comment about it, what's there? In other words, what they're saying is, we're telling you that there's no wetlands, but we're going to stand behind a provision in the contract that says you better go out there and find out. I don't think that's going to float. That's the way I see to get around that, if we get to that point. I don't know whether I've satisfied your question.
Yeah, I guess the reason I asked that question, to me, it kind of goes to your assertion that there is no remedy that the arbitrator could give based on the contract here. It seems to me that if that argument were to play out, the remedy would be, to basically rescind the contract and the parties go their own way. I mean, I understand your argument is there's no provision in here that speaks to what our remedy would be if there were fraud in the inducement. I get that, but I don't know any real estate or any other contract that would necessarily express that. So it seems to me that there is a remedy that the arbitrator could give in this case, in this instance.
And that would be?
I guess that would be to rescind the contract under this particular provision.
That's a possibility, but we need to get to that point. We're in a situation where a complaint's been dismissed and not even sent to arbitration, but it's been dismissed based on the arbitration clause, which does not give us any remedy.
Can a party not waive a particular remedy in accepting or in agreeing to an arbitration provision? Can a party not say?
Certainly. But if the arbitration, what I'm saying is the arbitration provision, I'm apparently not getting across, but the arbitration provision is void because it does not provide any remedy. In other words, it's fundamental law that for every wrong there's got to be a remedy. And that contract does not provide a remedy in this situation. It provides a remedy if the seller doesn't sell. It provides a remedy if the buyer doesn't buy. It provides a remedy if somebody's holding the escrow and they won't turn it loose. It provides those remedies, but it doesn't provide anything else.
Well, and maybe I'm confused, but if we look at some of the 5th DCA cases where they say that broad arbitration language incorporates a cause of action for fraud in the inducement, if that's true, then why doesn't the arbitrator here have the right to hear a claim for fraud in the inducement?
Because of that sentence in the paragraph 14A that I've gone back to, the arbitrator may not alter the contract terms, as that means add to it, or, and this is more particular, award a remedy not provided in this contract.
And that remedy, you're demanding the remedy for lost profits?
Damages, yes, sir. And possibly punitive damages based on fraud. And none of that's provided in this contract.
When did you plead punitive damages?
No, we can't do that until we get something on the record, and we have nothing on the record. Under 768.28, we can't plead punitive damages until there's record evidence.
Until you get some discovery.
Until we get some discovery. So, Judge Van Norfolk, I don't know how others
I understand. I follow. I understand your argument better now. Your explanation. I didn't understand it when reading the brief, but it's clear now. you've raised on appeal the access to courts issue. The appellee has asserted that was not preserved below, and you really didn't address that, I don't think, in your reply brief. How would you address that issue? Was it raised below?
There was, I think I addressed it in our reply brief, that was raised in a memorandum that we filed with the court in opposition to the motion to dismiss. And I believe you'll find that in our reply brief.
You said in your reply brief you raised it by stating that the arbitration clause was unconscionable.
Yes.
But nothing specific regarding access to courts. But you think that covers?
I would submit that it does, Judge Thomas. I've got about 5 minutes left, so unless you have any other questions specific at this point in time.
Good morning. I'm Jean Downing, and I represent the appellees in this situation. And to start where the questioning left off for the appellant, the record is at pages 39 through 41 is the motion or the memorandum that Mr. Ireland referred to, and that is points 2 and 3 in the appellee's brief, that issue of access to court and this issue of for every wrong there must be a remedy was not raised below. And we need to go back to the fact that this is a contract between two business entities that were dealing at arm's length. I think that the point regarding the record at page 10, the feasibility study, the fact that the contract required a feasibility study and due diligence by the appellees before they finished this contract.
But let's say, and I'm sorry to interrupt you so early in your argument, but let's say that the arbitrator says, well, I don't think that the due diligence requirement defeats the fraud claim here, just hypothetically. What kind of remedy, and he or she finds fraud in the inducement, that your client, I know you're not conceding this, but that your client knowingly advertised a 100% upland property, knew that it contained wetlands that would prevent development, and falsely advertised to the contrary. What remedy can the arbitrator award under the contract?
Obviously not conceding any of those factual situations. The arbitrator has a realm of remedies that he or she could give, rescission of the contract.
But that's just return of the deposit, right? A rescission of the contract would just be a return of any deposits paid and restoring the parties to the status quo ante.
Yes.
But but the plaintiff's demand is for lost profits. The purchase price was about $150, $160, as I recall. I mean, the purchase price here was $253. I assume who knows what the value of the property is now. But the allegation is the 9 units they couldn't develop out of the 27. The lost profits on those 9 units. Could the arbitrator award that?
I'm not going to concede that the arbitrator could award that.
I understand that. But let's say the arbitrator says, I find fraud. I find they were deprived of being able to develop 9 out of the 27 units. I think those are the numbers. That's about 1/3 of the value of the property in there for their purposes. He really cannot award or grant a remedy there, can he?
If the arbitrator did find that and did grant that award, there are remedies for my clients, the appellees. If we went in front of an arbitrator and the arbitrator went beyond what we thought they could award, he or she could award, then under the Federal Arbitration Act, we can then go to a district court or a court of jurisdiction.
No, I think my hypothetical points to the answer that and you're right, if the arbitrator did try and award lost profits, you certainly would have a claim under the Act to say, no, you don't have any authority under the contract to award those damages. So
But I'm not sure.
I'm not saying that defeats your argument on appeal, but isn't it true that there is no way under this contract and the arbitration clause for the arbitrator to award as damages the lost profits? That necessarily doesn't defeat your argument.
Right.
But the arbitrator cannot award that, right?
It doesn't appear that the arbitrator can award that. If you take the contract as a whole and if you abide by the arbitration. That
doesn't mean they didn't waive it or that they didn't bargain for that limitation.
Exactly. Right. And that's kind of...
But if that's the case, doesn't that lead us to a conclusion that the intent of the parties under the reasoning in Seifert was that this type of claim was not covered by the contract and not covered by the arbitration provision? I mean, if they don't have a right to make it under the contract, how could it have been intended to have been covered?
I think that's when you go back to the reason for the requirement of a feasibility study before the contract was
But that's a
completed.
defense to the fraud claim. It seems to me at the stage we are here, we're simply deciding who gets to make that decision. Once it's clear whether it's an arbitrator or a court, it seems to me that's where the feasibility study. I mean, that's a contractual defense, it seems to me, to the fraud claim. But I mean, at the stage of a motion to dismiss or a decision on arbitration, it seems to me that's premature to consider that.
I don't believe it is premature, Judge Van Northwick. I believe that it is very important to consider that because that goes to the party's intent. It goes to the fact that both parties should have come to the table to enter into the contract, to enter into the deed fully informed. And in Seifert, one of the concerns with the court there was that parties could have been injured that weren't a party to a contract. Here, these are both knowing parties to a contract. And if they can't get fraud claims, then they've waived it.
Well, I mean, you argued Beezer in your brief, which was well advised on your part because the second, citing the third, said that fraud in the inducement should be determined by arbitration.
Right.
So I see your brief and you've made the point. I guess the question now is, should we follow that logic?
And I would suggest that this court should. Beezer was very instructive, I think, for this court because it dealt with land issues. And on page 456 of that opinion, the 5th DCA discusses that the buyers below want a cause of action for fraudulent inducement. And the 5th DCA cited the long line of cases that have been referred to earlier and said that unless the fraud and the inducement went directly to, if Mr. and Mrs. Jackson somehow convinced the appellees to engage in an arbitration clause and fraudulently got them into that particular area. But this is a standard form contract. And one of the things, if this court is concerned with the public policy of arbitration in standard real estate form contracts, then that may be an issue that needs to be addressed by legislature, or if this court is concerned in this opinion, writes an opinion and it may go up to the Supreme Court, I'm not sure. But that may be something, that may be an area of law that needs to be clarified.
Well, in fact, has our Supreme Court addressed the issue of what establishes an arbitrable issue since Seifert? It seems to me we have DCAs speaking to that issue, but I don't think any of the cases you cited were Supreme Court cases. And I'm not sure we haven't really addressed it either. So the question I have is, I'm frankly concerned that the reading given by the 5th DCA in Seifert and McGuire conflicts with Seifert. Because Seifert, as I read it, it's a long opinion, and they talk about narrow and broad arbitration language. But then they talk about the fact if you're going to include a tort where the tort claim doesn't require an interpretation of the underlying contract, no arbitration of that claim is required. And Seifert, of course, addressed a very different tort than the one here, but I'm concerned that the 5th DCA has given a broader reading of this arbitration clause than Seifert has. And I agree with you, the Supreme Court deserves the right to make that decision ultimately.
And in Seifert, the very distinguishing element of the Seifert case was the contractual nexus between the parties that entered into that contract. I'm not saying I agree fully with the reasoning that somebody else could have brought that lawsuit in Seifert, and that was one of the reasons. I think that was one of the reasons why it was the broad arbitration clause was upheld in Seifert.
Well, you know, in one of the 5th DCA cases, I don't remember which one, their logic was, I think, upside down. They said, well, if there wasn't a contract, there wouldn't have been a fraud in the inducement. And I sort of said, that seems to me that if there wasn't a fraud in the inducement, there wouldn't have been a contract, is really the way to think about that. And I don't really understand. I'm troubled by the concept that someone, and I know you don't concede this, and I'm not saying this is the case here, that a party can commit active fraud, induce someone to enter into a contract, and then eliminate the very fraud cause of action that they benefit from by that contract, without expressly saying so. There's no, if this contract said, if we committed fraud, I hereby, the buyer hereby waives all cause of action for fraud, assuming that public policy even allows for that. If the contract said that, I would say, well, maybe that's the case. But that's not, there's no mention of a tort cause of action or a cause of action for fraud here being covered by this contract or this arbitration provision. And I'm really troubled by that. Don't know how I'm going to answer it, but I'm troubled by it.
I understand that you're troubled by that, but I think that under the Federal Arbitration Act, under the reasoning for even having arbitration, I mean, arbitration is something that business people enter into to avoid having to go through a slow court system to be able to get faster resolution to issues. And if in doing so they waive or concede some rights, then that's something that a business...
So you think there could be an implicit waiver here of any fraud claims? Could we read a waiver by the fact that arbitration's agreed to?
It could be. I mean, anybody who's entering into a contract should get counsel and should understand all the terms of the contract. And here, Heard and Heard Corporation and Shakespeare, they're business developers. They're in this for the purposes of developing land. And they entered into a contract, and if it has an arbitration clause, and that's a collateral damage, if you will, if it's collateral, the fact that they can't bring a fraud claim, then that's something they should get.
Well, under Seifert, if it's collateral, my understanding is under Seifert, that was kind of the reasoning there, was the personal injury tort, as I recall, was collateral, i.e. it was not something, essentially related to the contract. Is that correct?
In Seifert, it was personal injury issue, and the contract had to do with building the residence.
Right, and there was a personal injury, and the court said we must determine whether the tort claim arises from such a significant relationship to the parties as to mandate application of the arbitration clause. Now, that language obviously can be read in your favor.
Yes.
Because the fraud in the inducement tort claim obviously relates to the contract.
Yes.
So.
And that's part of, this is a breach of contract action. The contract was attached to the complaint. We can't read part of the contract without giving heed to the entire contract. And one of the other issues in this particular contract is that in most real estate situations, the contract is assumed once the deed happens. This arbitration clause was specifically set out to remain standing. And I know Judge Overstreet just did a one paragraph order, but I think that both parties briefs demonstrate that that's something that he considered, was that he had to consider, did this paragraph even survive the closing of the property? And it did. And that should have been a red flag warning for anybody entering into that contract, that perhaps there were some rights that they were giving up. And access to the court is not given up by going to arbitration. Should the arbitration award fall short, then I believe the proper remedy would be for the appellees to bring this argument to a court after, not before.
The appellants, you mean?
I'm sorry.
That's all right.
The appellants, that they should bring this argument to a court after the award if they're not satisfied with it. One thing I did want to point out, and I see that I'm almost out of time, was I do agree with appellants that this is a de novo standard of review, and that this court has the review of this case and the case law from scratch, and would ask that the court find that there was a valid agreement, that this is arbitrable issue, and that the ruling below should stand. Thank you.
Thank you.
I was about to deal with the standard review, but I think there's one thing we can agree on, that it is de novo, so you have it from the get-go. One of the reasons for arbitration, and the reason that the arbitration is favored by the courts and by the legislature, is not to have people do away with their remedies. It's to, as counsel said, have hopefully a speedy remedy that will get to a just decision. In this case, if that one sentence that's contained in that arbitration provision is what is the bothering point of it, terrible in English, the arbitrator may not alter the contract terms or award any remedy not provided in this contract. This is a standard realtor contract in Bay County. I've never seen it before, but it is in Bay County, and it's there, and it was signed. There's no question about that. The question for this court, I respectfully submit, is looking at Seifert to determine whether that was the intent of the parties at that point in time by that wording, that one sentence out of this multi-page contract, for our clients to waive any right they may have for actual fraud. This isn't negligent misrepresentation. This is actual knowing fraud. It says, accordingly, the determination of whether an arbitration clause requires arbitration of a particular dispute, the issue, one of the three prongs, the arbitrability, necessarily, quote, rest on the intent of the parties. The general rule, this is from Seifert, the general rule is that where an arbitration agreement exists between the parties, arbitration is required only if those controversies or disputes which the parties have agreed to submit to arbitration. If the drafter of this contract had intended to say, by signing this contract, you give up any rights that you have based on any fraud that's been perpetrated against you, that should have been.
But is that not a waiver to sign a contract that says you're agreeing to arbitration, and the arbitration will not include any remedies other than rescission, breach of contract, the typical breach of contract, damages, and of course sometimes I guess those damages will include lost profits.
I submit that it's not. I can't give you any other thing other than my opinion that is not, particularly when you have actual fraud prior to the entry of the contract.
Because your argument pivots on the notion that the arbitrator could not award you lost profits, right?
Correct. Based on this?
All they can do, as I said before, is restore you back to the position you were in before you signed it.
I'm not totally sure that that's even in the contract, but if that's in the contract, then that's what they can do. Unless you have any other questions, then I will close the rest of the time.
Thank you. Thank you, counsel. That's our only case on the docket for today. We'll stand in recess.